Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Mr. Secretary, would you please call the roll?
Assemblywoman Bilberry Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson.
Here.
Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Nguyen.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker. Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler. And Chairman Yeager.
Here. Please mark Assemblyman Orentlicker absent excused for the moment. He will be here shortly, and when he arrives, please mark him as present. That means we do have a quorum. Good morning to committee members. Good morning to those joining us here in the room in Carson City. Good morning to those on the Zoom with us and those who may be watching on the internet. Welcome to day 86 of the 81st session of the Nevada Legislature. Before we get started this morning, just a few quick housekeeping matters. For those who are in the room with us, if you could please silence your devices, that would be much appreciated. And when you come to the table to testify, please be sure to turn the microphone on, to state your name before you speak, and then to turn the microphone off when you are done speaking. For those who are on the Zoom, if you could please mute yourself when you're not speaking. And in addition, if you could state your name each time before you speak, that'll help our committee secretaries prepare accurate minutes. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy. That's perfectly acceptable, but we need to make sure we're being respectful of one another, of this legislative process, and most importantly, of our very hardworking staff. And then finally, many members are using multiple devices to access the meeting, so please don't see it as a sign of disrespect or inattention if members appear to be looking away at various times throughout this morning's meeting. With those behind us, we're going to go to our agenda. I am going to take the bills slightly out of order because we do have Senator Settlemyre with us here this morning, and I know he has a lot going on, as do the rest of us. So at this time, I'm going to go ahead and open up the hearing on Senate Bill 94 in its first reprint. That bill provides that an unlocked gate does not, in and of itself, constitute a public nuisance. Senator Settlemyre, welcome back to the Assembly Judiciary Committee. It's great to see you. We'll give you a chance to make your presentation, then I'm sure we'll have some questions.
Thank you, Chairman Yeager and Committee on Judiciary. My name is Senator Settlemyre. I represent Senate District 17, all of Douglas, all of Lyon, all of Churchill, and all of Story County. In that respect, this is not a new issue for this committee, to say the least. This started a long time ago when we ran into some issues where people were trespassing on private property, but because it wasn't appropriately marked, they felt, and they were actually getting away with it. We had situations where people were hunting on private property in the middle of green fields and killing animals and getting away with it. So we brought forth a bill stating that if it was cultivated land, then that was, you should make someone know, or should have known, that you're on private property. Well, then some people decided they wanted to stick in another bill dealing with locked gates, because we also have a problem on public roads where sometimes people will put a lock on it, and that's wrong. It's a public road, even though it traverses through private property. So we put a bill in last session that said also that you can't lock public road off. Well, unfortunately, the language came out so tight that it says you can't have an encumbrance on a road in any way, shape, or form. So some DAs read it at the plain language to state you cannot have a gate on a road. Well, if you have your own property and it's completely fenced off, it's kind of hard to keep animals in if you're not allowed to have a gate. So that's where this bill comes about. Just trying to state that an unlocked gate does not, in and of itself, constitute a nuisance, meaning that you can still have the gate you'd had on your property for 100 years out in the middle of nowhere. It's just stating that it's unlocked. You can open the gate, drive through it through somebody's private property, because again, they do have a public road through their private property. That's all it's about. Now, of course, when it started out, it had a much different rendition because, of course, I involved my local DA and he was trying to solve the world. And then my DA did not necessarily agree with another DA who didn't agree with the Cattlemen's Association, who didn't agree with the county commissioners, who didn't agree. Well, you can tell where this went. So in that respect, you'll have some opposition someday because some people want to try to hijack this bill in order to try to solve their problems. Overall opinion is, bring your own. I'm just trying to simply state that an individual has private property, has the right to have the gate they've always had, and that gate does not constitute a nuisance. because some of these counties are starting to say, okay, you need to take down that gate that's been there for 20, 30 years. Again, kind of hard to have animals on property without a gate. With that, I gladly stand for questions.
Thank you so much, Senator Settlemeyer. And indeed, I remember we've been building on this concept since at least 2017 when I started in this committee, and it may have been before that. So you are becoming a regular fixture here in the Assembly Judiciary Committee after first House passage. Just a quick question I had, and I don't want to relitigate what was done in the Senate Judiciary Committee, but I had a chance to sort of look back and see how the bill started, and it looked like there were quite a few revisions, which just really ended up in this one sentence that we have in on page 3 in the subsection 6. And just wondered if you could give a little bit of context about where the bill started and how it ended up being as simple as it is in front of us today.
Correct. Thank you for that, Chairman Yeager. James Settlemeyer again for the record. What it started out is that the counties wanted to try to address what are called SR 27 public access roads and all other public roads that are within a community. And they wanted to try to delineate that and get into the authorization of who had the authority to state whether there was a gate, not a gate, when that authority occurred, and wanting to retrace the entire lineage of that particular piece of property going back to the deeds or patents or all that. Well, that gets a little bit convoluted. I'll leave it at that. And so it seemed like it was much easier in order to try to find some form of agreement to just go to the crux of the issue, which was the concept of an unlocked gate.
Thank you. I have a question next from Assemblyman Wheeler.
Thank you, Mr. Chairman. Senator, as you know, as you're well aware, our districts, my district is encompassed in yours, and I get some comments, I should say, not nice comments, but some comments from some of our ranchers, et cetera, that I just wanted to say thank you for finally bringing this forward, and hopefully this will actually solve the problem. Okay, thanks.
Thank you, Solomon.
Assemblywoman Hanson.
Thank you, Chair, and good morning, Senator. It's good to see you. And I, too, am grateful for this bill. I'm a huge fan of SB 316 that passed in 2019, but yes, it did have some things that needed to be clarified. And then just for the body's edification and those listening, remind all of us what the rule is about a gate in Nevada. When you come across the gate, what are you supposed to do with that gate?
In my world, this is Senator Settlemeyer, in my world, you leave it how you found it. Simply put, sometimes an agriculturalist may have left that gate open because they're going to be moving cattle through it. So they'll come down to draw, and they expected that gate to be where they left it, and it was open. And they come all the way down, and it's shut. And that can create some rather large problems. So my adage is you leave it how you found it. Now, if the gate has a sign on it, please close the gate at all times. Well, then, in my opinion, the farmer should have put a spring latch on it or something to help make it do that. Because, again, sometimes when I'm running cattle, I like them left how I left them. So in that respect, as far as the other addition and some of the issues that came up with in 316, it was sponsored by an unscrupulous senator who had a similar name as someone on this committee. And I appreciated his issue that he ran into in the high country sometimes where someone would illegally place a lock on a gate restricting access to public property, and that's not allowed. And that's what the bill was originally about. Unfortunately, within the drafting, it came out that anything was, no encumbrances were allowed in any way, shape, or form. That, by definition, meant you could not have a gate, which again, to me, was not the intent of the bill.
Thank you. Have a question next from Assemblywoman Bilbray Axelrod.
Thank you, Mr. Chair, and thank you for bringing this bill and giving a little bit of context. While I was here in 2017, I did not have the pleasure of serving on this committee. So when I was reading this bill last night, my mind went to an unlocked gate and something in Clark County, like someone with a pool, perhaps, and an unlocked gate. And I'm just wondering if this statute, and I just don't know enough, would have any sort of unintended consequences possibly with public safety, especially for children.
I appreciate that. Senator Settlemeyer, for the record. This is dealing with the incurrence of what are called public roads. So that's what the bill is all about. So again, on people's private property, they will have an easement on there or a right-of-way to have a public road through it. Now, in some of those instances, though, for years you've had a gate on it, so people have the right to drive up on this public road, get out, open the gate, drive through, shut the gate, and keep going. So that's what the intent of the bill. And unfortunately, even with the language we had last time, it said no encumbrances. So I had people that were like, well, I got a cattle guard, and that's not a gate. Can I have the cattle guard? And some of the DAs were saying, well, no, not really. It says no encumbrance in any way, shape, or form. Well, then that creates the problem. And that's what this bill is trying to address, is that the gate in itself, it doesn't create a nuisance. So no, it's not meant in any way, shape, or form for complete private property situations where you don't have a public easement or a right-of-way in any way, shape, or form. That's what the intent of the bill is, just those unique situations. Sometimes those situations get created by the government. I have one piece of property that has a highway through the middle of it. Didn't start out that way. But, you know, a long time ago, it used to be a toll road where it was actually designed to be on the edge of the property. Well, toll roads were designed to go by houses. Well, once you started having cars go over 25, 30 miles an hour, you really didn't like the idea of having the cars right by your house. So they agreed to just actually donate some property, per se, and put 395 through the center of the ranch. Now, what's also humorous with that is no one's ever done any paperwork. I still actually own all of it. So, but that'd be the last thing I'd want to try to do on 395 is put up a toll road. I don't think I'd live longer than the afternoon.
Assemblyman Orentlicker.
Thank you, Chair, and thank you, Senator, for bringing this bill. I have a couple questions, not about what you're trying to do, but because we see all the statutory language, I noticed some rather archaic provisions that would be nice to delete as long as we've got this bill. So if you look on page 2, and the first one's on line 13, this subsection G, where vagrants resort. Now, I'm not sure exactly what that's intended to get at, but I could see it being misused against homeless people. So I'm not sure we want to keep that. And then on line 19, 3B, offends public decency, which could very well be unconstitutional. So are you receptive to taking those out?
Thank you so much. I appreciate the question. This is Senator Settlemeyer for the record. In that respect, I'm not familiar why those particular things were put into law, and I would be remiss to agree to take something out that may have been there for a particular reason that would then, if I was to agree to take out, that would really make the DAs happy with me in that respect. And as I indicated earlier, to me, it's always a situation. Of course, this bill is in your committee, and you guys can do whatever you want. You have the jurisdiction, you have the power and authority. I always suggest, though, that people bring their own rules and their own bills in order to try to tamper with things, because sometimes what seems like a real simple thing, well, that shouldn't be there, let's delete that. And then you find out that the reason they put in the public decency thing is you had some unscrupulous people that were on public property next to a school doing some very unpleasant things. And I'd hate to find out that that was in there for a particular reason, and I agreed to take it out. As far as where vagrants resort, I have no idea why that particular one is in there. It could be a situation where potentially the law enforcement or the DAs or someone needed the ability where they were having people congregate and they were creating problems such as fires or things of that nature. It just gave them the ability, not that they rousted them, but or it created a problem. So I do not know. I would be remiss without having to actually go back and research where those came in and talk to the DAs. And I can do that on those particular two for you and try to report back their general temperature. But since they already don't like the general temperature of the bill because they want it to go further, they may not exactly give me the best answer.
I appreciate your checking into that. Thank
We'll
you.
look into it.
Do we have further questions from committee members? Okay, before we take testimony, I did want to tell you, Senator Settlemeyer, that I think it was after last session, I had the chance to do my state parks tour, and I had the pleasure of driving from Elko to Jarbidge, and so I got a very firsthand view of the bills that we've been working on here in terms of gates, fences, signs, cattle running across the road. So it was quite an experience, and I want to let Assemblywoman Hanson know I did not tamper with any gates. I left them exactly as I found them. So if this guy from Southern Nevada can figure that out, hopefully everyone else in the state can figure that out. So Thank you for being here, Senator. What we'll do is ask you to step back for a moment. We'll take some testimony on the bill, and then we'll have you come back up for concluding remarks when we're finished with the testimony.
I appreciate that, Chairman Yeager. In that respect, I think you bring up a very valid point. I think it's behooving upon all of us to travel into each other's districts, break some bread, maybe even try to talk with other legislatures and get to know one another. Because unfortunately, in this cycle we have nowadays, we don't have the time to do that. So if we can find some time in the middle, maybe we'll meet in the middle. Thank you, Chairman.
Thank you. Very well stated. So at this time, we will open up the hearing for testimony in support of Senate Bill 94 in its first reprint, and we'll start here in Carson City. Mr. Davis, welcome, and please go ahead.
Thank you, Mr. Chairman, members of the committee. For the record, my name is Kyle Davis, today on behalf of the Coalition for Nevada's Wildlife. It's great to be in front of your committee in person for the first time this session. We are here in support of this legislation. We appreciate Senator Settlemyre working with us on the Senate side. We were one of the groups that when the bill first came out, we did feel it was overly broad. We did work closely with Senator Settlemyre and Senator Hansen last session on SB 316. And thought that was a very important bill for public access to public lands. And we think that the bill that you have in front of you today is in keeping with the spirit of that bill, making sure that we clarify that yes, a gate is allowed. It is important for people that do work out on our public lands, but that people still have the ability to get through that. So we think this bill is consistent with that bill that we were supportive of last session. We appreciate the senator working with us this session, and we are in support of the bill as written now. Thank you.
Thank you, Mr. Davis. Anybody else here in Carson City who'd like to testify in support? I don't see anyone coming forward. I don't believe we have anyone on the Zoom in support. BPS, could we go to the phone lines to see if there's anybody there who'd like to give supportive testimony?
Good morning. Thank you, Chair. For callers wishing to testify in support of Senate Bill 94, please press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 196. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. I'm Eric Spratley, S-P-R-A-T-L-E-Y, and the Executive Director of the Nevada Sheriffs and Chiefs Association. We're here in support of Senate Bill 94 and appreciate Senator Settlemyre bringing this important bill today, as this proposes to alleviate the kind of conflicts our sheriff's offices deal with quite regularly regarding access throughout the state. We would ask that this bill be considered in the version that it is in. We thank this committee for considering it. Thank you, Mr. Chairman.
Thank you for your testimony, Mr. Spratley. BPS, do we have additional callers in support?
Yes, Chair. Caller with the last 3 digits of 214. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Martin Paris, M-A-R-T-I-N-P-A-R-I-S. Chairman and members of the committee, again, this is Martin Paris. I'm the Executive Director of the Nevada Cattlemen's Association. I'm calling in today in support of SB 94 and appreciate Senator Settlemyre's efforts on the bill. SB 94 seeks to clarify that a private property owner can place an unlocked gate across a public road without it being considered a public nuisance. This bill is in response to SB 316 passed last session, which made it a public nuisance for any person to prevent or obstruct free passage on public roads that cross through private property. We believe that the intent of SB 316 was to stop private landowners from locking gates and not allowing access on public roads that cross through private property, which is appropriate. However, the way NRS 202.450 reads currently, fencing or otherwise enclosing a public road that passes through private property is a public nuisance. The current statute is being interpreted to mean that a private landowner cannot have a fence with a gate at all, even if that gate remains unlocked. It's very important to farmers and ranchers that they be able to maintain the ability to fence their private property and add a gate to contain livestock. Running livestock on private property is impossible without the ability to fully enclose the property. So SB 94 makes the necessary changes to statute, allowing private landowners to be able to utilize their properties without facing penalties, and we respectfully request that this committee pass SB 94. Thank you for your time.
Thank you for your testimony, Mr. Paris. BPS, could we take the next caller in support, please?
Next caller with the last three digits of 318, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. This is Kendra Bertschy, Kendra Bertschy with the Washoe County Public Defender's Office. This morning, I'm testifying on behalf of my office, as well as for John Puro with the Clark County Public Defender's Office. We want to thank Senator Settlemyre for working with us on this bill. He was able to alleviate our concerns with the current revision of the bill that you see before you. It addresses all of the issues that we had, and we really appreciate working with the senator on this bill and have seen him since, again, 2017, working on this issue, and we hope that this will finally suit the needs of his jurisdiction, and we urge your support. Thank you.
Thank you for your testimony, Ms. Bertschy. BPS, could we take the next caller, please?
Chair, there are no other callers in support at this time.
Thank you so much, BPS. I'll close testimony in support. I'm now going to open it up for testimony in opposition. Is there anyone here in Carson City who'd like to testify in opposition? I don't see anyone coming forward, and I don't believe we have anybody on the Zoom in opposition, but let me just take a look over there to make sure. Right, I don't see anyone turning on their camera or unmuting. BPS, could we go to the phone lines to take testimony in opposition there, please?
Thank you. For callers wishing to testify in opposition of Senate Bill 94, please press star 9 now to take your place in the queue. Callers wishing to provide opposition testimony for Senate Bill 94, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you, BPS. I will close opposition testimony. I will now open it up for neutral testimony. Is there anybody in Carson City who'd like to testify neutral on the bill? I don't see anyone coming forward. I don't believe we have anyone on the Zoom in neutral. BPS, could we go back to the phones and see if there's anybody there, please?
My apologies, Chair. For callers wishing to provide testimony in neutral of Senate Bill 94, please press star 9 now to take your place in the queue. Caller with the last three digits of 241, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. My name is Alex Ortiz, ELEX-ORTIZ, representing Clark County. I do apologize. I missed the opposition testimony time. Is it possible to still testify in opposition?
Yes, Mr. Ortiz, so just give me 1 minute. I'm going to close neutral testimony for the moment. I'm going to move back to opposition. I'll reopen opposition. Please go ahead, Mr. Ortiz.
Chair Yeager, I do apologize for that, but thank you also for giving us a couple minutes to speak. Clark County opposes Senate Bill 94. I do want to thank the sponsor, Senator Settlemyre, for taking time to discuss our concerns today. However, the provisions of this first reprint are overly broad. There's no context or specifics related to the intent of the bill. It can relate to any gate, anywhere, on any road, or on any property. It also conflicts with NRS 202.450, subsection 5, which makes it a public nuisance for any person to fence, enclose, prevent, or obstruct free passage or transit over a road. It needs to be narrowed to define the scope of the subject matter, which is understood to be certain roads under certain conditions. Now, that said, Clark County and NACO and Eureka County actually worked with the senator on a proposed amendment that addressed all of our concerns and the county's concerns. And unfortunately, we were not able to come to an agreement on that amendment. But we would like to continue to work with the senator and see if he would consider our amendment. Once again, I do want to thank the senator for meeting with us yesterday and look forward to working with him on this bill. Thank you, committee, for your time today.
Thank you for your testimony, Mr. Ortiz. I'll now reclose opposition testimony. Let's go back to neutral. We are on the phone lines. BPS, could you check to see if there's somebody there in the neutral position, please?
Thank you, Chair. For callers wishing to provide testimony in neutral of Senate Bill 94, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 929, please slowly state and spell your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 929, please press star 6 to unmute yourself and begin your testimony.
Hi, Chair and members of the committee. My name is Colby Prout. I'm from NACO. We actually were looking to testify in opposition as well. Apologize again for not getting in. Would you like me to continue in neutral, or would you like to reopen as you did with Mr. Ortiz from Clark?
So at this time, I will reclose neutral. Making me work today. I'm going to reopen opposition
Apologize.
testimony. No, it's fine. So we'll go back to opposition testimony. Please go ahead, sir.
Okay, thank you, Chair. Members of the committee, again, my name is Colby Prout, C-O-L-B-Y-P-R-O-U-T. I'm the Natural Resources Manager at the Nevada Association of Counties. NACO does appreciate the sponsor's time and his willingness to meet with us and consider our amendment. However, we do oppose SB 94 in its current reprint. The reprint of SB 94 does look to reconcile a current issue in existing law with a simple approach but we do feel it may still result in undesirable outcomes because of its overbreadth. Specifically, it undermines the county's ability to ensure public health and safety by allowing gates across moderately and even heavily trafficked roads. It may also jeopardize county authority over title over roads throughout the state and undermine county's ability to regulate and ensure the functionality of the roads they're charged with maintaining. Again, we do thank the sponsor for his time and consideration of the amendment that we put forward, and that hope he may consider it going forward as well. Thank you again, Chair and members of the committee, and apologies for not getting in at the proper time.
Thank you so much for your testimony, Mr. Prout. BPS, before we go back to neutral, could we just do one more call for opposition testimony, please?
Yes, thank you, Chair. For callers wishing to provide opposition testimony for Senate Bill 94, please press star 9 now to take your place in the queue. Anyone wishing to provide opposition testimony for Senate Bill 94, please press star 9 now to take your place in the queue. And Chair, I believe there are no other callers in opposition at this time.
Until we get back to neutral, but for now, thank you, BPS. I will reclose opposition testimony. Let's go back to neutral. BPS, could you check to see if there's anybody there who hopefully would be in the neutral position?
Yes. For callers wishing to provide neutral testimony for Senate Bill 94, please press star 9 now to take your place in the queue. Callers wishing to provide testimony in neutral of Senate Bill 94, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers in neutral at this time.
Thank you, BPS. I'll close neutral testimony. Welcome Senator Settlemyer back to the table to present any concluding remarks on Senate Bill 94 in its first reprint.
Thank you, Mr. Chairman. Appreciate that. Again, within the bill, we made it simple to make it simple. In that respect, if you look at it, an unlocked gate does not, in and of itself. And our legal on our side said, and the drafters, we're going with the concept that obviously, in and of itself. So if you show that the road is paved, well, then guess what? You better take down that gate. That'd be unreasonable. In and of itself. If the road was such a nature that it caused a problem, that would give the ability for the county to say, no, that's a nuisance. But if it's just a gate in the middle of nowhere, in and of itself, not causing a problem, it should be allowed. The amendment that came forward had language in it that stated that the property owner would hereby assume all liability for the entire course of the road through their property, period. That was one of the more egregious things that the property owner said, wait. So you're saying that on my private property, somebody's trespassing, no matter what happens, it's 100% my fault? That doesn't make a lot of sense. If someone's driving through my property going 60 miles an hour and they flip over their vehicle and they get hurt, I think it's kind of their fault for driving unsafe conditions. Why is it now? Why does the burden go to me 100%? It's those type of languages that the amendment tend to lose me, or rather, I apologize for my language, lost more support than it gained with the amendment, and therefore the amendment was not brought forward. And as you can see, the simple discussion of a gate is not that simple. So we tried to leave it at just that. I will try to look into the Assemblyman's concerns to try to research why those things were put into law and try to get him the answers to satisfy him in that respect. But I greatly appreciate your time. If you have any other concerns, my email is clearly listed. Please contact me. Thank you for your time.
Thank you so much, Senator Settlemyer. It was good seeing you here this morning, and we hope you have a great rest of the day. I'm now going to close the hearing on Senate Bill 94 in its first reprint. Committee, we're going to take the other two bills out of order just to accommodate some scheduling issues. So at this time, I'm going to open up the hearing on Senate Bill 8 in its first reprint. Senate Bill 8 in its first reprint revises provisions governing guardianship of minors, and I believe we have two of our family court judges here, one from the 8th Judicial District, and that would be Judge Marquis, and one from the 2nd Judicial District, and that would be Judge Schreinert. Hopefully I got your name right. I don't think we've had a chance to meet yet, but want to welcome both of you to the committee this morning. We'll give you a chance to make some remarks about what the bill does, and then I'm sure we'll have some questions. So welcome, and whoever would like to start first, please proceed.
Thank you, Chair Yeager. Yes, and you did pronounce the name right. I am Tamitha Schreinert. I am a judge in the 2nd Judicial District Court. I serve as the judge in Department 14, Family Division. In addition to custody and divorce cases, I oversee all of the minor guardianships for Washoe County. I also serve as a member of the Nevada Supreme Court Permanent Guardianship Commission, and the Guardianship Commission is in support of SB 8. In 2017, if you recall, the guardianship statutes were rewritten to separate out adult guardianships from minor guardianships. When this occurred, the provisions for transferring and registration of minor guardianships was left out, although those provisions are in the adult guardianship statutes. SB 8 mirrors the provisions from the adult guardianship statutes and places them into the minor guardian statutes. In addition, SB 8 clarifies the definition of a child's home state, ensuring it conforms with other child and family statutes, specifically the UCCJA, which is a law that all states follow to ensure that only one state at a time is making orders regarding a child. And finally, SB 8 allows for the appointment of guardianships in Nevada if the child is present and it's in the child's best interest, even if Nevada is not yet their home state. I'll provide brief examples for each provision. Section 2 of the bill allows the ability to transfer a Nevada guardianship out of state with permission from the court. When a guardianship has been in place in Nevada for several years and the guardians and the minor are granted permission to move to another state, they may have difficulty obtaining a guardianship in the other state due to the fact that they have an open guardianship case in Nevada. This amendment will make the transition easier by allowing the transfer of guardianship to the other state, and then the Nevada guardianship case would terminate. Section 3 allows the transfer of an out-of-state guardianship to Nevada with court oversight and findings. For example, grandparents who've had a guardianship of children for years and they receive a new job in Nevada and get their state's permission to move here with the children. This amendment will allow the transfer of their guardianship to Nevada, but also require them to complete a full petition so we have all of their current information and make best interest findings. Sections 4 and 5 allows the registration of an out-of-state guardianship in Nevada, again with court oversight and findings. Litigants have believed they could register an out-of-state guardianship similar to registering an out-of-state custody order, but we have no authority to do so under the current 159A, the minor guardianship statute. So for example, A guardian who moves to Nevada may wish to register their out-of-state guardianship if the minor is near their 18th birthday and they don't need any changes to the guardianship, or if the guardian lives in California and the child goes to school in Nevada. As you know, some of our towns are split down the middle with the state border. There, the guardian would only need to register the guardianship because they still live in the other state. Section 6 defines home state to conform to the UCCJA, again, the law that states all follow to ensure that only one state at a time is making orders regarding a child. When a person petitions the court for guardianship, they are asked to disclose any other cases involving the child or courts that may have jurisdiction over the child. And this amendment allows Nevada courts to accept and release jurisdiction of a child pursuant to the UCJA, which is very common in other child and family cases. And finally, Section 7 allows guardianship to issue so long as the child is present in Nevada and it's in the child's best interest to do so without having to make a family wait for 6 months until Nevada becomes the home state. This section also clarifies that guardianships can be issued when the court has authority to do so under the UCCJA. An example of when we might need Section 7 is if a family moves here during summer break and needs a Nevada guardianship to enroll in Nevada schools, but the family will not have been here for 6 months until long into the school year. Oftentimes, caretakers in guardianship need to add the child to their medical insurance when they have recently moved to Nevada. And we currently have authority to grant a temporary guardianship, but our insurance companies often require full guardianship in order to put the child on the medical insurance. This amendment will allow Nevada courts to grant guardianships when it's in the child's interests, rather than having to wait 6 months to do so. Myself and Judge Marquise and the Guardianship Commission, thank you for our ability to present the bill today. Judge Marquise and I had divided our time in that I would provide our statement, and I will hopefully be available for some questions, but I do have a court hearing, and then Judge Marquise is available for questions as well. Thank you so much.
Thank you so much. Appreciate it. Nice to meet you virtually, and hopefully we'll have a chance to meet you soon in person. Judge Marquis, welcome to Assembly Judiciary. It's good to see you, and please go ahead with any remarks that you have before questions.
I have no remarks, Chair Yeager, but I am happy to address any questions.
Great. Thank you so much. We do have a few questions so far. I'm going to start with Assemblywoman Cohen.
Thank you, Chair, and thank you both for the presentation. I just have a couple of questions because I just want to clarify some things and make sure I'm following. So in Section 6 with that home state definition, the new language is lived with a parent or a person acting as a parent. If the child is under state care, is that encompassed within that definition?
I'll take Assemblywoman Cohen. Do you mean in state care, as in the foster system, or involved in that court?
Right. Yes.
All right. Generally,
and Judge, could you just remember to state your name, please?
I'm sorry. Thank you. Again, I'm Judge Marquis. If there is an open and active abuse and neglect case, generally we wouldn't see any action in the guardianship case. That case would be open and active, and there's a different type of guardianship under 432B that has different rules, and that may be an option for guardianship if that's happening. Certainly, if somebody was with a foster parent and placed with a foster parent for a period of time, and the abuse and neglect courts have taken emergency jurisdiction because their jurisdiction is a little bit different than ours, we could still have jurisdiction over a 159A guardianship, arguably, but I don't know that would happen quite often.
Okay.
Did that answer your question?
Yeah, thank you. It's a field where I don't do a ton of work, so it's so I did want to make sure I understood that. So even if there's like a placement, even if it's relative, fictive, that type of thing, it still would be considered under 432B, not, and probably wouldn't come into play here, is what I think I'm hearing.
So I say, this is Judge Marquis. I say generally because there is a certain action and a certain finding that the abuse and neglect judges have to make in order to start their jurisdiction under 432B guardianship. They have to find that the child is in need of protection, and then make a case plan and adopt the case plan. So before they do that, we could still have jurisdiction under 159A. After they have that hearing, then we do not have jurisdiction, and 432B guardianship is appropriate.
Okay, thank you. And then I also want to make sure that I'm following this. So in the new language, the difference between a temporary guardianship and a permanent guardianship isn't necessarily an issue, because the language just refers to guardianship without making that difference in most of the places in the new language in the bill.
Sure. So this is Judge Marquis again. When we talk about transferring or relocation under guardianship, the only type of guardianship that may be transferred or under which you may relocate to another jurisdiction is a full general guardianship and not a temporary guardianship. Under the rules, we can only give a temporary guardianship for a period of 120 days, and we must have a status check every 60 days to see that family. And that's generally while we wait to have an evidentiary hearing. That's a temporary order. So we don't see under a temporary order a request to relocate. You can only request to relocate outside of the jurisdiction when you have a general guardianship. And this resolves some of the issues about temporary versus general, because like my colleague up north said, insurance companies will not honor a temporary guardianship. Many medical providers will not honor a temporary guardianship, and many schools will not honor a temporary guardianship. They require that full general guardianship so that the care provider or guardian may sign them up for school, get dental treatment. Certain types of medical treatment are unavailable to children who are under a temporary guardianship.
Okay, thank you.
Do we have additional questions from committee members this morning? All right, I'm going to look over this direction. I don't see anybody with their hands up. How about over here? I don't see anybody either. So I think those are all the questions that we had. Would ask you both to hold tight for a minute. And Judge, we know if you have to go for your hearing, certainly welcome to do that. I know Judge Marquis can pinch hit with any concluding remarks. So again, thank you for your presentation. At this time, I'm going to open it up for testimony in support of Senate Bill 8 in its first reprint. Is there anybody here in the room in Carson City who'd like to testify in support? I don't see anyone running up to the table. I don't believe we have anyone else on the Zoom with us in support. BPS, could we go to the phone lines to see if there's anybody there, please?
Thank you, Chair. For callers wishing to provide testimony in support of Senate Bill 8, please press star 9 now to take your place in the queue. Callers wishing to testify in support of Senate Bill 8, please press star 9 now to take your place in the queue. Chair, there are no callers in support at this time.
Thank you, BPS. I'll close testimony in support. I will now open it up for testimony in opposition. Anybody here in Carson City in opposition? Everyone looks busy doing other work out in the audience, so I'll take that as a no. I don't think we have anyone on Zoom with us in opposition. Judge Bell's here, but I believe she is in support of the bill, so we won't go to her for opposition. Anybody on the phone, BPS, in opposition, please?
Callers wishing to testify in opposition of Senate Bill 8, please press star 9 now to take your place in the queue. Callers wishing to testify in opposition of Senate Bill 8, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition.
Thank you, BPS. I will close testimony in opposition. I will now open testimony in the neutral position. Anyone here in Carson City in neutral? Nobody here in Carson City. Nobody on the Zoom in neutral. BPS, could we go to the phone lines one last time for this bill to see if there's testimony in the neutral position?
Yes, Chair. For callers wishing to testify in neutral of Senate Bill 8, please press star 9 now to take your place in the queue. For callers wishing to testify in neutral of Senate Bill 8, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers on the line at this time.
Thank you, BPS. I will close neutral testimony, and I will now hand it back over to our two presenters if you'd like to make any concluding remarks on Senate Bill 8 and its first reprint.
Thank you, Chairman Yeager. This is Judge Markey. I think this really just resolves the omission from the 2017 legislation and really mirrors the language in the adult statute. And it would be a great help to our citizens and the kids in Clark County and all over the state, sorry.
Thank you so much, Judge. Judge Schreiner, any concluding remarks?
Yes, just briefly, I mirror those comments from my colleague down south that this will really help us serve the families here in Washoe County and throughout the state, and I appreciate your consideration. Thank you.
Great. Thank you. Thank you too so much for spending a little bit of time with us this morning in Assembly Judiciary Committee. It's always nice to have the experts with us, and certainly hope that you two have a great rest of your day and a great rest of the week. Thank you so much. So I will now close the hearing on Senate Bill 8. Moving right along, we're back to the first bill listed on our agenda, and that would be Senate Bill 6 in its second reprint. So I now will open up Senate Bill 6 in its second reprint. That bill revises provisions governing orders for protection against high-risk behavior. Welcome back to Assembly Judiciary, Judge Bell. It's good to see you. Please go ahead with your presentation, and then I'm sure we'll have some questions.
Thank you. Good morning, Chair Yeager and members of the committee. My name is Linda Bell, and I'm the Chief Judge of the 8th Judicial District Court in Clark County. Last legislative session, the legislature passed a bill authorizing high-risk protection orders in certain situations to remove firearms from people who are engaging in high-risk behaviors. And I'm going to share some statistics from Clark County and then walk you through the bill. So since this statute passed, I presided over all of the high-risk protection order applications in Clark County, except for one where I had a conflict. While presiding over those cases, it has become apparent to me that there is a great deal of confusion for people applying for these types of protection orders. So the goal of this bill is to simplify and streamline the process to make it simpler and a little clearer when people apply for the high-risk protection orders. Since the law went into effect in Clark County, we've had 33 applications. 25 of those were seeking other types of protection orders. For example, people filing for domestic violence protective orders or workplace harassment protective orders, and they just didn't understand that they were applying for something other than a protective order for themselves. Of the 8 who were actually applying for a high-risk protective order, 3 were granted in some capacity or another. 1 was granted on a temporary basis but not extended, and that was a community applicant. The other 2 were extended orders that were law enforcement applicants or the adverse party. In both cases were present at a noticed hearing and did not oppose the granting of the order. The other 5 applications were denied for not meeting the standards set forth in the statute. I also understand in checking with Washoe County that they've had a handful of applications, less than 5, and that none have been granted to date. Part of the confusion that I've seen lies with the different procedures that someone has to follow depending on what type of protection order the applicant is seeking. So they can file an application for what is called an ex parte order in the law currently, or an extended order, or both. And so the way that the form looks, there's two check boxes, and depending on which one the applicant checks, it can result in having to have 2 hearings in a 7-day period. And even some of our law enforcement agencies have struggled a little bit with the process, which has resulted in some delays in getting the applications heard. The bill changes the terminology in the law by using the term emergency order instead of ex parte to just have it more accurately reflect what that short-term order is. An ex parte order is typically defined as an order made by the court without notice to the other party. As the law stands, in this case, the short-term order, the 7-day order, can be issued with notice or without notice, so that term doesn't necessarily apply. So just as a change to better reflect that we're granting a very short-term 7-day order to give time for the court to make sure that the parties are noticed and have a full hearing with witnesses if that's necessary. Section 1.3 and 1.5 streamline the application process so that there's just one application for the high-risk protective order. Section 1.3 allows for one application that can either be granted on an emergency basis if that seems appropriate to the judge, or the court can decline to issue the emergency order and just set it for a hearing to consider whether there should be an extended order after the adverse party has had notice and then been able to come in and present any evidence against the application. Section 1.5 requires the court to schedule a hearing no later than 7 days to determine whether an extended order should issue, if an emergency order is granted or if it is not. Regardless, there would still be a full hearing. Section 4 adds conforming language to show that the applicants have to show that the individual possesses an imminent risk to themselves or others. This is another area where in some of the applications that have been denied that there's been a little confusion where people are applying based on things that happened several months in the past. So it just mirrors, the judge needs to make a finding that there's an imminent risk. And so this mirrors that throughout so that the applicants have to show that there's an imminent risk to themselves or others. It also allows applicants to provide and encourages applicants to provide supplemental documentation and information to the court, which is really helpful, particularly when the court is looking at whether to issue an order on an emergency basis, to have documentation such as mental health records or police reports or anything else that may support the application. The law also currently provides that service, if there is only an application for an extended order, that service needs to be effectuated under the Nevada Rules of Civil Procedure. This created some safety concerns for the person serving the papers and a little confusion about when a law enforcement agency sought only an extended order but hadn't served the adverse party before the application could be heard. So it just eliminates that to reduce confusion on that front. Under section 4, that requirement is removed. I will note that the public defenders reached out to us with some concerns about the adverse party not being served the application. So we're working with them so that if the emergency order is granted, then under section 9, the appropriate law enforcement agency would serve the application along with the emergency order and notice of the hearing, just to make sure that the adverse party has all of the information that they need to prepare for the hearing if they are opposing the application. Section 8 removes the ability for the adverse party to surrender a firearm to someone who does not reside with the adverse party, and just has, if the firearm is surrendered, then it would go to a law enforcement agency. And then finally, the bill removes the duty of the court to assist the parties. We are always happy to work with community organizations to educate the community about the protection orders, and our clerks, to the extent they can, try to help people to file papers. But under the current law, it puts our clerks under a difficult position regarding legal advice, and we want to make sure that the right entities are doing that, and not our clerk's office. And with that, I'm happy to answer any questions that the committee has.
Thank you, Judge Bell. Appreciate the presentation. Just wanted to clarify a couple of things for the record. I believed you indicated that you're speaking with the public defenders about a potential amendment, but there's not an amendment that's being offered right now. That's one that might come after some further discussions.
That's right.
And then the other question I had, I think I got the numbers you had said. It sounded like, as far as you're aware, that only 3 of these have been granted in some fashion throughout the state. And I'll say, I guess, at least when you consider Clark and Washoe, it sounds like you're aware of 3 being granted, and then it sounded like a handful that were applied for but ultimately denied. Did I get the numbers right there?
This is Linda Bell, and that's correct. So I understand that what I believe is there's 10 or 11 applications between Washoe and Clark County. 3 of those have been granted in some capacity. 1 was temporary, the extended denied, and so just 2 extended, and neither of those were opposed by the adverse party.
Thank you, Judge Bell. Do we have questions from committee members for Judge Bell? Assemblyman Wheeler.
Thank you, Mr. Chairman. Your Honor, when we're taking ex parte to emergency, I understand we spoke about this a little bit offline, but I have another question for you on that. Even though it goes to an emergency instead of ex parte, it can still be one-sided, right, which is what ex parte means. It can still be an ex parte case, but just reclassifying it. So my question is, would someone still be able, to file a grievance against another person without that person's knowledge under the emergency as they would under ex parte?
So this is Linda Bell. So the law currently provides for the application to be with notice or without notice ex parte. And nothing about these amendments change that. It just changes the terminology to a more correct term because it can be with or without notice. So it would still allow community applicants without notice to the adverse party.
Okay, thank you.
Okay, we'll go next to Assemblywoman Gonzalez.
Thank you so much, Chair. Assemblywoman Gonzalez, District 16 for the record. Thank you so much for presenting this bill. I know we spoke a little yesterday about the it just being with people in the same home, and I just can't remember. So if I wasn't living with somebody and I wanted to report or get this order, what is that process like? Or what court would I need to file that in? Because I know some of the issues is folks not knowing where to file the correct petition, I guess you could say.
Thank you for that question. This is Linda Bell. So the family member applicant, the family member applicant, I believe was something that was very seriously considered 2 years ago, and the policy consideration that the legislature ultimately decided on was what is currently in the statute now, and nothing about this amendment changes that. It allows certain people with certain family relationships, if they have a child in common. So there are some circumstances where the people would not have to reside together, but they have to fall within the definition of a family member as set out in the statute. Then those people have the ability to file the application. If somebody was outside of that, then they would need to contact law enforcement, and law enforcement would make a determination about whether to file an application or not.
Thank you so much.
Do we have additional questions for Judge Bell on Senate Bill 6? Assemblyman Wheeler?
Sorry, Mr. Chairman, I'd like to take another bite at the apple, if you don't mind. Could you explain to me, Your Honor, the automatic hearing on an extended order? If the emergency is already denied, what is the purpose of having that if the emergency is already denied?
Thank you. This is Linda Bell. So, we as judges, I think, always like to have hearings with both sides present and give everybody the opportunity to present any evidence that they have. The way the statute is written allows for the order to be granted if there is some sort of emergency, but then requires a full hearing. So both sides can come in and present anything that they want to present. So if there isn't a sufficient basis to grant the emergency application, it allows then both parties to come in without having the ex parte removal of firearms and present their respective sides, so the court then can then make a determination with all of the information from both sides. So it could be that an emergency order is not granted, the hearing is set, and then the extended order is also not granted. It just would depend on what information was provided at the time of the hearing. It's to make sure there's a full hearing and both sides have the opportunity to provide information.
Okay, thank you very much.
We have a question from Assemblyman O'Neill.
Thank you, Chair. Judge, when they come in to present their cases, either side, are they represented? Does the district attorney of the county represent the original party, and are they allowed legal representation?
The district, thank you, this is Linda Bell. The district attorney does not represent the community applicant. The cases that we've had so far, there have been law enforcement applicants where we've had the extended hearing, and then the one community applicant we had hired private counsel.
Thank you, Judge. Thank you, Chair, for the time.
Any additional questions from committee members? Okay, I don't see additional questions at this time. Thank you, Judge Bell. We'll ask you to hold tight for a moment. We'll see if there's any testimony on the bill, and then we'll come back for any concluding remarks. At this time, I'll open up for testimony in support of Senate Bill 6 in its first reprint, or excuse me, its second reprint. Is there anybody here in Carson City who'd like to testify in support? There is no jockeying up at the table, so let's go to the Zoom. I don't believe we have anyone there, but let me just take a quick look. I don't see anyone on the Zoom. BPS, could we go to the phone lines to see if there's anybody there who'd like to testify in support?
Yes, Chair. For callers wishing to testify in support of Senate Bill 6, please press *9 now to take your place in the queue. Callers wishing to provide testimony in support of Senate Bill 6, please press *9 now to take your place in the queue. Chair, there are no callers in support.
Thank you, BPS. I will close testimony in support. I will now open testimony in opposition. Anyone with us in Carson City who'd like to testify in opposition? Nobody's coming to the table. We don't have anyone on the Zoom. BPS, could we go to the phones to see if there's anybody there in opposition, please?
For callers wishing to testify in opposition of Senate Bill 6, please press *9 now to take your place in the queue. We will take caller with the last 3 digits of 527. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 527, please press *6 to unmute yourself and begin your testimony.
Hello, everybody. Sorry for the delay. My name is Kimberly Fergus. I'm from Las Vegas, KIMBERLY, Fergus, FERGUS. I'm a little confused here on this SB6. However, from what I gather, this has to do sort of with the red flag law, and there's pending litigation on it being ex parte. Isn't ex parte stripping people of due process? To me, this can make criminals of law-abiding citizens. There should be the highest standard to deprive someone of their rights. Instead, this makes court proceedings secret to the accused, with a vindictive relative able to make baseless claims. Nevada deserves legislators who protect the rights of all, including gun owners. That's all I have to say. Please vote no on this amendment to SB6. Thank you. Have a great day.
Thank you for your testimony, Ms. Fergus. We hope you have a great day as well. BPS, is there anybody else on the line in opposition?
If you have recently joined the call and would like to testify in opposition of Senate Bill 6, please press *9 now. Chair, there are no other callers in opposition at this time.
Thank you, BPS. I'll close opposition testimony. I will now open neutral testimony. Anybody in the room with us here in Carson City who'd like to testify neutral? Nobody's coming forward. We don't have anyone neutral on the Zoom. BPS, can we go to the phone lines one last time for this bill to see if there's anybody there in the neutral position?
Yes, thank you, Chair. For callers wishing to testify in neutral of Senate Bill 6, please press *9 now to take your place in the queue. Callers wishing to provide testimony in neutral of Senate Bill 6, please press *9 now to take your place in the queue. Chair, the public line is open and working, but there are no callers at this time.
Thank you, BPS. I will close neutral testimony. Judge Bell, any concluding remarks on Senate Bill 6 and its second reprint?
Yes, thank you, Chair Yeager. Linda Bell again, and I understand that there are in some of my conversations that there are those who have some fundamental disagreements with the law itself, and I want to just make clear that I am certainly not taking any kind of policy position here. That was determined 2 years ago, only trying to make the existing law work better for the members of our community, to make this statute a little more streamlined in terms of how it operates. And thank you for everybody's time today.
Thank you so much, Judge Bell. Appreciate the time. And please do let us know if there are additional amendments that you're able to work on with the public defenders. If you could just provide that to us, we'll be sure to include those in any potential work session. So again, thanks for being here this morning, and we hope you have a great rest of the day.
Thanks, you too.
I will now close the hearing on Senate Bill 6 and its second reprint. That takes us to our final agenda item this morning, which is public comment. Just by way of reminder, public comment is a time, we reserve up to 30 minutes for public comment at the end of each meeting. Public commenters will have 2 minutes to provide public comment. Public comment is a time to raise matters of a general nature within the jurisdiction of the Assembly Judiciary Committee. So, for example, this is not the time to sneak in opposition testimony on Senate Bill 94. That time has passed several times over in the last hour. So at this time, we're going to go to public comment. Anybody in the room here in Carson City who'd like to give public comment? I see a lot of head shaking no. We don't have anyone on the Zoom for public comment. BPS, could we go to the phone lines to see if we have public comment there?
For callers wishing to provide public comment, please press *9 now to take your place in the queue. For callers wishing to provide public comment, please press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 556. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Anne Marie Grant, ANNEMARIE-GRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office. Today I'd like to talk about Micaiah Lee. Micaiah William Lee was 18 years old when he was shot and killed by Sparks police officers Ryan Patterson and Eric De Jesus. Patterson fired 5 shots. De Jesus fired 2 shots immediately after that. Eric De Jesus also shot and killed Jorge Marino Aguirre 7/28/2016. And Ryan Patterson is also a 2-time community member killer. He was one of 3 cops who shot and killed Jose Dominguez 4/28/2019, less than a year before he would kill Micaiah. City of Sparks police were called to take a suicidal teenager they knew to be severely mentally ill into custody for his own safety, but within minutes of approaching him, shot him dead. City of Sparks officers had the time and opportunity to assess the situation, employ tactics and accommodations recognized by nationally accepted police practices and training to peacefully resolve the situation, specifically by using de-escalation techniques, communication, and crisis intervention. If the officers had utilized proper training in the fundamental principles of maintaining a covered position to calmly communicate with an emotionally disabled person rather than hysterically screaming commands, loudly cursing, and sadistically using an attack dog and cruelly rushing the teenager with lights and sirens blaring, the incident would not have happened. At the time Micaiah drove off, he was not wanted for a crime and there were no outstanding warrants for his arrest. He was in the middle of a serious health crisis and his mom did what we all been told to do. She called 911. And she pleaded with them on that call not to shoot her son. Sadly, minutes later, Ryan Patterson and Eric De Jesus would kill Micaiah, who was completely silent at the time. He did not utter a word, charge the officers, run towards the officers, make a threatening gesture, or threaten to harm the officers or try to flee as they had disabled the vehicle. I don't want any more mothers or families knowing this heartache. I ask that you support bills that promote transparency and accountability. If law enforcement oppose the bill, I ask that you support it. Thank you.
Thank you for your public comment, Ms. Grant. BPS, are there additional public commenters on the line?
If you have recently joined the call and would like to provide public comment, please press star 9 now to take your place in the queue. For callers wishing to provide public comment, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 527. Please slowly state and spell your name for the record. You have 2 minutes and may begin. Caller with the last 3 digits of 527. You may now begin your testimony. Caller with the last 3 digits of 527, you are unmuted. You may be muted at your end. We will move on to the next caller with the last 3 digits of 766. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin. My apologies, Chair. That caller hung up as well. There are no further callers for public comment at this time.
Thank you so much, BPS. Appreciate all your help this morning. I will close public comment. Committee members, now that we've gotten through bills on gates, guardianships, and guns, is there anything else from any committee members this morning? All right, I don't see anything. Let me just give you a quick lay of the land on where we go from here. We do have a meeting tomorrow. Tomorrow's meeting is going to be at 8 o'clock because we have 3 bills, and I think they may take a little bit more time. So just to make sure we have adequate time, we'll have 3 bills tomorrow at 8 o'clock. Thursday's meeting is at 9 a.m., and there will be 2 bills. And we will not be having a Judiciary Committee meeting on Friday morning. So Friday morning has been canceled. So we just have a couple more days yet this week, and then when we get to Thursday, I'll be able to give you a better sense of what next week looks like. After this week, we have 2 weeks to a second committee passage deadline, so we'll be working hard to hear the Senate bills that we have over here in the committee. Committee, as always, I appreciate your attention and hard work this morning. I hope you all have a great rest of the day, and I will see you back here in this committee tomorrow morning at 8 a.m. This meeting is adjourned.